Are we good to go, Chad?
Yep, good to go, Tim.
Thanks. Okay. Well, thanks everyone for coming. Good afternoon. Welcome to our webinar, Civility Matters. It's presented by the Negligence section of the State Bar of Michigan and the Michigan chapter of the American Board of Trial Advocates. My name is Tim Diemer. I'll be serving as the moderator today. Before introducing our speakers, I was hoping to share one personal anecdote where I was a beneficiary of an act of courtesy and professionalism when I was a brand new lawyer many, many years ago. And this is still fresh in my mind to this day. My first year in practice was with the Michigan Court of Appeals as a research attorney, which did not present any opportunities to appear in court. Instead, my first court appearance occurred shortly into my time in private practice under less than ideal circumstances. I was at my desk on a Monday morning about 9:30. A senior partner of the firm peeked his head in the office and saw that I was wearing a suit and tie, which was the firm's dress code, at least for associates. The partner, on the other hand, was in golf attire. Apparently, that's what he had planned on doing that Monday morning. And as a result, he had completely forgotten that he had a summary disposition hearing in Flint. Because he was not dressed for the occasion, he asked me to fill in. It was a plaintiff's case that I had no involvement in whatsoever until that 9:30 meeting. I was a defense side appellate attorney at the firm. So again, I had nothing to do with this case. The briefing, didn't know the name of the client, didn't know what was going on. And I had less than an hour to get to court for the hearing. So while driving 70 miles an hour on northbound on 975, I had to prepare my argument, read through the briefing. I was, of course, in a complete panic. This was my first court appearance. I did my best to put thoughts together about what to say about a case I knew nothing about. Doing legal research, preparing an outline was completely out of the question because I'd never been in court before. I had no idea where to check in, who to talk to, where to sit. I was completely unprepared on both the procedure that morning as well as the substance for my first court appearance as a brand new lawyer. From the case caption, I was able to learn the name of the defense attorney, who was probably in his 60s at the time. He could have easily used the situation to his advantage. I was totally rattled, and under the circumstances, the odds of me presenting a coherent argument were virtually non-existent. But that's not at all how the defense attorney handled the situation. He came up to me, introduced himself, shook my hand. He could tell I had no idea what I was doing, and he correctly guessed that this was my first court appearance. He told me where to stand. Sorry, my computer just froze. He told me where to stand. He said, plaintiff's attorney, stand near the jury box. He told me how to check in with the clerk, how to state my appearance on the record, and how to address the court. Knowing this, he had a surefire victory in hand, but his professionalism and civility outweighed any strategic advantage he saw. Rather than let me flail and win that motion hearing, he helped a young lawyer, and that is a lesson I've never forgotten. And I try to carry his level of civility with me in my own practice 2 decades later. Now, 2 other things I'd like to share about the experience. First, I won the motion hearing, which was a great feeling, but it was also an impossibility if the other attorney did not do the right thing when he saw a young lawyer in trouble. And secondly, in a completely bizarre coincidence, one of the other attorneys arguing that morning for the same motion call in a different case, of course, was some guy named John Jacobs. I would later join John's firm just a few years later. And I have to imagine if he had been there in person and saw me, this brand new lawyer, completely bomb a court appearance, and he was there to watch it, he may not have seen me as a worthy candidate to join his firm. So as indicated from the start, the courtesy from opposing counsel is a lesson I will never forget, and I try to carry that spirit with me to this day. One last thing before I introduce our speakers, I want to plug an upcoming negligence section webinar on neuropsychology in jury trials. You can see it there, Tuesday, June 7, 2022. Topics will be, what does cognitive science tell us about how humans make decisions? Can the choices, context, and framing all drastically influence group dynamics and decisions? Consider the impact of cognitive biases and decision process trial lawyers face every day, and especially in jury trials. Tune in for answers to these and other pressing questions on June 7th. It is now my turn to step aside to turn the proceedings over to our 2 esteemed panelists. Tom Behm of the Gruel Mills Law Firm in Grand Rapids, and Bob Riley of Riley and Hurley in Southfield. I have gotten to know both of these fine gentlemen through our service on the Negligence Council, and the universal adoration and respect they engender is a testament not just to their legal skills, but also to their civility and the manner in which they choose to practice law. Both Tom and Bob are past presidents of the Michigan chapter of ABOTA. Tom is immediate past chair of the Negligence Council, and Bob is the current chair. And it is the negligence section. It consists of half plaintiffs' lawyers, half defense lawyers. We're adversaries. And both Bob and Tom have done a wonderful job finding consensus on issues where we can agree, bringing people together. It's a very, very challenging job to do. And both of them, because of their character and their integrity, have done a wonderful job of it. One final remark: during the course of the presentation, feel free to submit questions. If you submit them under the Q&A tab, the question and comment will go to everybody. If you have a question or a comment directed just to the panelists, you please use the chat function. And if it's a question for the panelists, I will do my best to direct it at the appropriate time of the presentation. Without further ado, please welcome Tom Behm and Bob Riley.
Tim, thank you. It's a pleasure to be here. I want to welcome everybody to our presentation this afternoon. It's great to be with so many warm, familiar faces. It's good to have all of you here. This is going to be an exciting seminar. We've got a lot to share with you. Before we begin, though, I want to take just a moment and thank the State Bar of Michigan Negligence Law Section for allowing us to do this, to help sponsor us in this endeavor. This is a difficult topic. We don't all act civil as we should, and so we're going to have some fun talking about this topic today. So it's great to see everybody. It's great to be here. Bob?
First, let me thank the State Bar Negligence Law Section, but in addition, thank the American Board of Trial Advocates. It is also an organization made up of both plaintiff and defense lawyers. The criteria for the organization's invitation to membership requires that individuals be vetted for integrity, honorable conduct, and most importantly, civility. Their endorsement of this program is a reflection on their priorities as an organization. I also thank Tim for agreeing to work with us. Chad Engelhardt from the section is here as well, assisting us. Madeline Lowry, Matt Hinkle, and others from the Executive Director's Office, all have played an important part today, and we thank them. Finally, and most important, please accept my thanks. We're grateful for the opportunity to share some perspectives, give some context to an important issue, civility among lawyers.
There is a civility problem in the legal profession. The real question is, why does this exist? Some might say that it's because of the dual obligations we have in terms of representing our clients and our duty of loyalty to our clients. And sometimes that competes against our duty to the profession and to the courts in which we appear in that we have a duty of candor. And sometimes that can cause challenges. Others may say that COVID's to blame. Certainly COVID has challenged us in this area. Others may say, no, it's really the internet. The internet is to blame. The reason we hit send as quickly as we do is really a lot to do with the internet. Whatever the reason, we can probably all agree that there has been a substantial lack of courtesy between lawyers. We see a lack of discipline in terms of individuals and how they conduct themselves. And maybe perhaps overall, there is an enormous lack of self-awareness. We want to start our program by showing you a video. And I want to set the stage for this video. It is a jury selection in a minor criminal case in the state of Florida. The person standing next to the podium is the public defender in the blue sport jacket. He is going to be discussing a few things with the judge, who is off camera, but you will hear the judge, and you can see the ladies and gentlemen in the jury box. Let's drop in on a typical day in Florida and see how our legal profession performs.
All right. If you want to set for docket time, set for docket time. I'm not waiving in any case. This is an emergency
if I
created by
had a
the
rock,
state.
I would throw it at you right now.
You know, this is
Stop pissing me off. Just sit down. I'll take care of it. I don't need your help.
No,
Sit
you know
down.
what? I'm the public defender. I have a right to be here, and I have a right to stand
I said
and represent
sit
my
down.
clients.
If you want to fight, let's go out back and I'll just beat
Let's
your
go
ass.
A truly amazing video. So what's the purpose of this program? Why are we here today? Bob?
This is not a program designed to tell you to behave. That's not our objective. Our objective is to give you context and self-evaluation in terms of a number of key thoughts. A lawyer's roadmap to civilization or civility in a civilized manner, in a civilized system, would involve the elements I'm about to describe. Principle, structure, application. The first concept, principles. It is our assessment that lawyers need context, the underlying principles. So our first topic is going to be devoted to that. Thereafter, we're going to move to structure, how you structure yourself in your practice to address the principles of civility. And our final and third topic is the application or the outcomes that we hope an understanding of principles and your own structural modifications or evaluations will allow you to have applications or outcomes or results that are consistent with what you would want for yourself as a professional. And in addition, and perhaps most importantly, what you would like for your clients. Next slide. We have before you the ABOTA, American Board of Trial Advocates Code of Professionalism. Again, my goal or objective isn't to have you learn and memorize the principles, but we do ask that you consider the kinds of professional codes that exist for a wide variety of organizations. And as ABOTA makes it clear in its code, your behavior, that which inspires integrity, that which shows honor to the profession, is codified in a way that simple and clear and understandable principles are available to you. This isn't just true, for example, in the organization that sponsors this particular event. Next slide, please. The American Inns of Court, another professional organization, has a creed, and it too focuses on underlying principles which are of value to a lawyer, whether young, beginning, starting a career, those in the depths of a career with more work than you know what to do, or those at the tail end who are still managing cases, particularly those who are frustrated with the management of cases as they age and get cranky, easily distracted. These principles apply to them as well. And the American Inns of Court, as with ABOTA, have put together the kinds of underlying principles that are worth considering as you evaluate your practice and how you comport yourself. Tom?
Thanks, Bob. In addition to those two organizations who have promulgated codes of conduct, our own Michigan Supreme Court in December of 2020 issued an order where it identified guidelines regarding civility. You should have received an email from us regarding this order and should have received a copy of it. In this order, the Michigan Supreme Court sets out a number of principles of professionalism. These are the principles that we all need to follow as attorneys licensed to practice law here in the state of Michigan. Let me just review a few of them with you if you haven't had a chance to look at this. And we've got a few up on the screen, and as you can see, we need to show civility in our interactions with people involved in the justice system. We need to cooperate with people involved in our justice system. We can't engage in intolerance or conduct that is viewed as rude or threatening or obstructive toward people. We're told not to disparage or attack people involved in the judicial system or employ gratuitously hostile or demeaning words in our written or oral communications or pleadings. We're to treat people involved in our judicial system fairly and respectfully, notwithstanding differences of perspective, viewpoints, opinions. Those are just a few of the many principles that are set forth by our Supreme Court. And here's a few additional ones. We only make good faith and reasonable requests for time extensions, and we also agree to such requests. This is our Supreme Court basically instructing and providing principles to all of us. We're to act in good faith. We're to be reasonable. We're to be agreeable. We also need to act reasonable and good faith in scheduling hearings, meaning before we schedule a motion, before we schedule a deposition, we're encouraged to contact our opponents to see if we can't work out an appropriate date. In other words, we're being asked to do and engage in the same type of conduct that we all hope is employed on us. We're supposed to be respectful and considerate of personal emergencies. Those are tall orders if we're in a very stressful situation. And let's face it, the adversary proceedings that we find ourselves in on a daily basis are oftentimes extremely stressful. There's high emotions, there's expectations by clients that are clearly competing against one another. There are oftentimes very differing points of view. There are half-truths all over the place. And there also can be factual misunderstandings or inaccuracies. With a background like that, it's important for us to make sure that we employ some of these principles so we don't engage in conduct that later becomes embarrassing to all of us. There are also additional civility principles from the federal courts. Bob?
The Eastern District of Michigan, as well as the Western District of Michigan, has specifically codified in considerable detail that which is expected of those who practice in those two venues. These are important because while one might consider the Michigan Supreme Court's professionalism guidelines as just that, guidelines, and as we have come to recognize, they're seldom raised, at least up to this point in their history, as a basis for substantive discipline for violations. This is not the case in federal court. And this is not an optional or guideline-driven set of standards. And I am personally aware of incidents which have occurred in both the Eastern District and the Western District, in which penalties or sanctions or revocation of pro hoc status occurs. So as one reviews the handouts which we have distributed and walks through the incredible detail that is associated with these federal court standards, please recognize that these are enforceable, that motions can be filed relative to misbehavior, that decisions can be rendered regarding alleged violations, and that those alleged violations not only potentially trigger financial consequences or license contexts, it can be irreparable damage to your reputation to have been so sanctioned. So we submit these to you as an important guidepost of enforceable civility standards that are relevant to your practice. I'll segue from that to one other point. I referenced the Code of Professional Responsibility by implication. There are standards there as well. And it is not a great step to move from a federal court determination that you have lacked civility or integrity to have the matter referred from the court to the Attorney Grievance Commission for potential investigation. Again, this is real and it's evolving, and it is important that those who are evaluating the principles that are applicable to civility recognize that we are gradually moving, perhaps slowly in state courts, but I would predict eventually to have civility principles that are in fact highly enforceable for those who elect to ignore the guidance these standards present. Tom?
So what are these principles that we've talked about really mean? And Bob and I think that if we boil it down, it really is best reflected in what we've got on the screen now, the golden rule. Do unto others as you would have them do unto you. It's easy to say, but it's not always easy to do. Here's a case in which the golden rule was cited back in 2010 because of the incivility of people involved in the case. I won't go into detail, but you can see there that the court recognizes that we work in an adversarial system. And as attorneys, we have certain degrees of pressure placed on us by clients and others. And notwithstanding those obligations and those duties, we still have to act with a high degree of civility and respect toward one another. That's what our profession requires. That's what is really mandated from all of us. And here the court suggesting that we need to treat each other with that respect and that courtesy. And the golden rule reminds me of a statement that Mark Twain once made, and that is, it's like forgiveness. it's a good idea until you have to do it. And really, that's what we're talking about here. We're talking about exercising a fair amount of civility in our practice, a little bit of grace. Everybody needs that. And everybody also needs to recognize that we're not always in a position to act the way we should. There are competing pressures on all of us. And so the golden rule is something that Bob and I both feel is important and kind of sums up this whole area of principles. We want to turn next, recognizing these principles exist, to how do we structure ourselves so that we can adopt these principles. Bob?
So the segue between principles to structure is important. And I'd like to give you a personal example. I will confess that I have not always evidenced the kind of civility that I could be proud of. As Tom just referenced, there are incredible stresses in the work we have. To illustrate this, I'll acknowledge that I once had a case that had considerable stress. We had had 2 mediation sessions with incredibly difficult issues among lawyers who were incredibly difficult to work with. For our 3rd session, we elected the Friday after Thanksgiving, and that was to be a date when everybody could agree. We commenced the 3rd mediation at 10 in the morning. Around 2 in the morning, mind you, we're now in the middle of the night, we are still going. And it was tense, it was difficult, and while we'd made progress on a wide variety of issues separating us, a new development came in where an innocent person who had really nothing to do with the case at all was now implicated, and the opposing counsel making an issue of this, in effect, innocent party who had no right to even be brought into the case was now added, and settlement demands changed accordingly. Now, mind you, I've been there since 10 in the morning. It is now, we've missed lunch, dinner. It's way past everybody's bedtime, and it's 2 in the morning and we're still there. I will confess that I figured out a way to combine every curse word I could assemble into a monologue that lasted about 10 minutes. The mediator said, Bob, please stop. But I ignored that. And I continued my rant for quite a while. Finally, we were separated. This was a 3-person meeting between the mediator, opposing counsel, and myself. At that point, we were separated, and the mediator said to me, Bob, you're absolutely right, but you are horribly wrong. Okay, I cooled off. We finally got our resolution at 5 in the morning. So we were there 17 hours. As I left that morning, this is now Saturday morning after Thanksgiving, I contemplated what I did. Yes, I was glad the case was settled. I felt good for a few minutes, again, using every combination of obscenity that I could possibly pack into a sentence. But frankly, I was also quite ashamed. And as I pondered this, I owed this person who I found totally offensive an apology. So I did. I crafted a thoughtful letter, the best I could do to apologize for my actions. Now, why is this important? It's the segue between the golden rule and other principles to consciously thinking about how we structure ourselves for civility. In other words, I knew going into this session that it was going to be difficult. But had I thought how to structure myself, what would I do if? if such and such presents itself, what will the response be? Knowing how difficult the parties had been, what would my response be in given situations or circumstances during a tension-filled process of all times interrupting the Thanksgiving break, when one would, of course, much rather spend time watching a football game, enjoying family members, eating too much, enjoying leftovers, planning for the upcoming December holidays. I was still wrong, and the tensions that we describe in our practice were fully evident. So as we now segue into the discussion of structure, here's where I'm coming from. And Tom and I have agreed on this, that we have to contemplate our work. We have to think through what it is we're called upon to do. And apart from just formulating pleadings or arguments or deposition questions or the argument we're going to have on motion day with a difficult attorney, or more importantly, a difficult judge, how have we planned, my words, planned, but our group presentation to you, how have we structured ourselves to deal with such matters? And that, I think, is at the heart of this program that we've brought to you today, is to walk through structural process for that which we do as lawyers. Tom?
Just following up a little bit more on that, structuring ourselves, it's imperative that we recognize the importance of structuring ourselves and how we're going to respond to difficult situations that we know we're going to encounter. That is key and critical in becoming a civil lawyer with high integrity. Civility begins with structuring your practice in a way to promote civility. That may take the form or the shape of agreeing to reasonable extensions, making sure your staff knows that you'll do that. It can take all kinds of forms, but it also requires fostering integrity and becoming conscious of your demeanor and your tone. Oftentimes there's more than one way to say something. And when you're under stress, when you're under pressure, when you're juggling too many things, the way you say something is perhaps even more important than what you say. So recognize that. Be self-aware. Understand that you will be in situations where people are going to treat you in an uncivil manner. That's going to come. That's part of the work we do. You've got to decide ahead of time how you're going to respond to that. When someone treats you uncivil, are you going to respond in kind? Are you going to fire off an email that will likely turn into an exhibit that could haunt you for a while? Or are you going to take a time out? You need to come to an understanding as to how you're going to respond to those very predictable situations long before they occur. It's also important to recognize that you're going to find yourself perhaps in even more difficult situations in depositions, in hearings, in mediations. Those are all things we need to think about as we structure ourselves to respond to the inevitable uncivil conduct we're going to get. And the people who do that better, who keep their cool when everybody else is losing theirs, those are the kind of people that we want to emulate. What Bob and I are really talking about is we want you to think about, how do you become the best version of yourself? What do you need to do to be the best version of who you are? What do you need to say? How do you need to act? When do you perhaps need a timeout yourself? And how to gauge when things go awry. So with that bit of background, let's go to our next slide, and we're going to talk about civility during depositions. All of us have been in situations where the civility in a deposition has become too much. conduct of counsel during depositions has been an area where civility is lacking, where discipline is significant, and it's an area that we all need to focus on. We need to make sure that we do not take the bait. We all know what that means when someone raises their voice, changes their tune or their tone, asks the same question for the 16th time, makes an unnecessary comment, tries to coach their witness. We've got to decide way ahead of time how we're going to handle that. And we need to have this structure, because without the structure, gang, we will not be able to respond the way we want to respond to exemplify the best version of ourselves. Let's take a look now at a deposition. You're going to see on the left side of your screen, the lawyer who's blocked by the screen there, he's asking the questions. The deponent is on your right, and the deponent's counsel is kind of in a green and white check shirt, who's going to, shall we say, have a meltdown. Join with me in looking at this.
Contents of the computer with regard to the searchable index that DuPont gave you, especially the field of addressees that say none, is DuPont's exhibit number 1. Is DuPont's exhibit
Counsel,
number 1.
I can't work like this.
Calm down. Come on, take a
Counsel,
Xanax.
first of all, you have no right to even claim an exhibit. It isn't your deposition yet. That's number 1, counsel.
So you've taken it off and torn up the exhibit.
Sir, you're not going to touch it. How dare you? You are going to go before the Bar Ethics Committee on this one, son. We're going to quit the deposition right now for the day so that you can rethink what you're doing.
So there's a great example of a lawyer who has no structure, didn't think about how he may respond to a situation, and has an absolute meltdown. There's no doubt that that deposition video is going to get played before the judge. There's also no doubt that that lawyer stands a good chance of being admonished by the judge that he's appearing in front of. And yet we see that. We may even have been in situations similar to that ourselves, and we know that that occurs far too often. So in situations like depositions, where there can be a lot of anxiety, a lot of stress, and here the lawyer's trying to mark an exhibit, and you can see the anger that that promotes. We've got to, as lawyers, have a plan, have a structure as to how we're going to handle those kind of situations. And if we are going to be baited into that situation, we've got to decide, okay, how am I going to respond to this? What type of actions am I going to engage in? Do I need to take a time out? Because if we don't, we find ourselves in those situations where instead of having the best version of ourselves, we probably have the worst version of ourselves. Let's take a look now at conduct of clients. This is another area that we may not directly control, namely our clients, but ones that we have to be thinking about as we structure ourselves and as we advise our clients as to how they should respond. These are unique problems because you don't always know how your client is going to respond. So you need to prepare them accordingly to make sure that they also show the type of respect and courtesy that you expect from them. Otherwise, their conduct could also be an exhibit before the court long before the matter ever goes to trial. Let's take a look at this next one. Oh, we got to go the other way. There we go. This is the witness.
Don't nail me on that.
Did you obtain prior approval for the association for that shed?
Actually, I'm assuming you people to the files, the building files, and all the other necessary files. If you haven't, you're a fool. Actually, it was an accommodation that we spoke about, and we never made it. It was an accommodation, and we never made a formal application about it. And if you take exception to it, I'll put it back where it was, which is right on the killer's line. You want me to do that? I'll be glad to. Today, tomorrow, next week, that's where it was. It was on the survey. It's on the survey. And I gently removed it. Am I going to be punished for it? Good. I'll put it back.
Was that a yes or a no?
It was a fuck you. What's your question?
Another example of a completely unstructured response, yet not an uncommon response in many cases. It's interesting here, as you look at a deposition, the principles that ABOTA sets forth on civility, integrity, and professionalism offer this: never engage in conduct which would not be appropriate in the presence of a judge. That's a good principle to have when you're structuring or instructing your client. Otherwise, you find yourself in this situation. But it's also interesting, if you look at that clip, what you see is opposing counsel starts this process by asking a question about, did you obtain prior approval for that shit? Now that type of question needs to be stopped immediately. As a lawyer, you need to recognize when things are escalating, and you need to take steps to de-escalate those type of comments, and of course the response that follows. You may need to take a time out. You need to have a little bit of self-awareness. You really need to exercise some discipline. And you don't want to engage in this type of conduct or have your client or witness engage in this type of conduct, because it can have dramatic impact on your case as a whole. These are just two examples of depositions. Bob and I came across literally tens of hundreds of examples that are similar to this, that we probably have all seen in the past. And there's things that you need to do to structure yourself, your witness, to prevent that. Let's now turn to something that perhaps is even more common, and those are written communications where people lose their cool. Bob?
So structuring oneself regarding your correspondence is in theory pretty easy. What rules do you have for yourself regarding your emails or your letters, pleadings, briefs, mediation summaries? In other words, what is it you're doing as a matter of custom, habit, professional routine to structure yourself for appropriate correspondence? This is a particular concern to Tom and I, and to many people that we've talked about, that over the last 2 years, with remote work being the overriding tool we have for meeting our needs, both as lawyers and as advocates for our clients, we've become isolated. We aren't with other attorneys on a regular basis. The examples that we normally see and rely upon for how to conduct ourselves aren't with us. There's nobody down the hall to go to vent. And what we're seeing is an increasing lack of civility simply by pushing send and not thinking about what it is you're doing, what its implications are. And there is a complete lack of discipline. Translated, the lawyers who are most problematic had no structure to guide their correspondence. Next slide, please. This is an example of the kind of thing that reflects a total lack of structure, and that Mr. Jones of Urbana has correspondence that's highly problematic to Jason. As you read this, I hate your expletive-ing existence. What you did to my property was a vicious attack against the sumac cover planted by Irene, et cetera, more important, as far as I'm concerned, in the 26 years that I have practiced law, I have never met, in a limited basis, a more despicable, self-made, once again, swear words, slime bag, and I piss on your existence. What I want to tell you specifically is to take this letter and jam it up your hole, resulting in severe paper cuts. Not very original, by the way. You are used condom of the highest order. Not very clever, but hey, it was an attempt. Maybe that was meant to be humorous. Guess what? A $5,000 sanction. Why? An attorney for writing a letter that the court found objectionable. This was inappropriate, and the sanction fits because of what occurred here. An example of a lack of structure, no matter how angry you are, how upset you are, at least with correspondence, you have a pause mechanism. This is something that you could and should build into your approach to self-evaluation. Do I fly off the handle when I get an email I don't like? When I pick up the mail and read a pleading that I find offensive? When the mediation summary that my opponent submits suggests I lack integrity, do I go prove the point by obscene remarks back to the attorney saying, he's an idiot, he's a jerk, worse yet, he's an asshole or whatever. The point being, how are you structured to respond via correspondence? And the easiest answer and the best answer is, have you structured yourself to pause, resist? Tom and I have compared notes about the 24-hour rule, that if it's really important, pause, don't react, think, rethink, and think again. Be disciplined, resist the temptation. I also have another recommendation, that as you consider your correspondence, are you making it exhibit quality? Let's analyze the concept. Exhibit quality refers to how whatever it is you submit in writing will be used by others. Think about the letter that you get regarding something as simple as, can I have an additional extension of time to answer X, Y, and Z? If you respond and say, your horse's ass, you haven't done a damn thing in this case, you're a lazy SOB, we're months behind our discovery deadlines, and I'm sick of dealing with you. Absolutely not, asshole. Okay? Don't think we haven't seen that. The point is, when the motion to extend is filed, and your response is an exhibit to the motion, where are you? Is the merit that you had because of delays that were not attributable to you going to be helpful when this correspondence is seen, reviewed, and considered by a judge? Hey, it takes a lot of patience by a judge to overlook that kind of obnoxious response. Couldn't you have said instead that the deadlines have passed? I've tried to be cooperative. I would like to accommodate you, but there are certain things based on the court's scheduling order that make me fearful of being able to do this. I'd prefer not to, but I won't oppose your motion if you file it. Pretty simple. You've structured yourself to have an accommodating approach to an issue. You've explained why it's difficult. Maybe you get a better outcome. We're going to talk about outcomes in a few minutes. But what are you achieving if you lack the structure to stop, pause, and look at the big picture? How am I structured to act? What are my principles that I apply to my correspondence, whether email, letter, pleading, or otherwise? And if you can answer those questions, evidencing the type of built-in discipline and the kind of routine habits and practices that evidence a structured approach to difficult situations, you'll be further ahead. Next slide.
Gang,
Civility in the courtroom. Tom, will you take that, please?
absolutely. Civility in the courtroom. We saw a bad example of it earlier, but what if your trial judge isn't civil? Does that ever happen? It can. Our Michigan Supreme Court Administrative Order, the guidelines that were set back in December of 2020, specifically says that the principles of professionalism require judges to be courteous, respectful, and civil in their opinions, mindful that they contribute in a substantial way to the public's faith in our system of justice and rule of law. That requires courts to treat people with respect, courtesy, patience, and to be mindful of their tone and their temperament. Here's a copy or part of the United States District Court for the Western District of Michigan civility principles, which encourage the court to be courteous, respectful, civil to lawyers and parties and witnesses, and not to employ hostile, demeaning, or humiliating words in opinions or in written or oral communications. That can happen. And we know that some of the things that Bob and I have received speak to this very issue. What do we do if we're up against a court or a judge rather who is not being civil? Those are important things to consider, and perhaps sometimes our courts need to be mindful of that as well. Now, what about consequences for behavior that is not civil in the courtroom? This next slide depicts a situation where many of us have been, namely a remote argument at the Court of Appeals, where we have our three-member panel of judges and our attorneys who are arguing the appeal. This has become commonplace in the last couple of years, and people are sitting in their office or in their library or wherever the case may be, and this occurs where someone makes a gesture or someone engages in some type of conduct that can be perceived as being completely improper. This happened in this case. This was an oral argument in our Court of Appeals, and one of the attorneys engaged in a hand gesture that was picked up by the video, and you can see there's a picture of the bird there in the lower right-hand corner of the screen. And that is an example of losing your structure, engaging in conduct that perhaps you would never engage in normally, but because you've lost structure, you've lost your focus, you're not thinking ahead, and you engage in conduct that can only hurt your reputation. It's important to recognize that if you find yourself in a situation where you have not responded properly and you have not engaged in the best version of yourself, that's going to significantly impact your reputation. It's going to cost you time and money, embarrassment. It's going to have a negative impact on your integrity. And oftentimes others will be talking about it for years to come. It can also, as it did in this case, next slide, result in a sanction. Humiliating, embarrassing, costly, no structure, no self-discipline, no self-awareness. What happens when this occurs? If you find yourself in that situation, you need to apologize. Recognize how important that is in a situation where you've lost your cool, to apologize quickly and recognize what's taken place and acknowledge what you've done wrong. Let's turn now to the applications, the outcomes, and the benefits from engaging in civil behavior. Bob?
As we began our program today, our focus was on that which you can do for yourself to have a civility plan. As we discuss applications or outcomes, results, let's focus on things that are important and obvious first. By way of example, your personal reputation is important. By having understood and becoming aware of important principles and structuring them in your practice, there's a key application that emerges almost immediately, which is your personal reputation. Whether you're the top trial lawyer, whether you're a beginner, whether you write contracts and negotiate their terms, it doesn't matter what area of the law you're in, your reputation will be shaped in large measure by the civility you demonstrate. So apply principles in a structured way to your practice, and the application will occur almost automatically. Another example is the results you obtained for your clients. Recognize that you have to deal with opposing counsel in any number of ways, whether this is through negotiations, whether this is through assembling dates to conduct discovery, whether this is in a motion hearing and the kinds of accommodations you need to make to obtain the basic facts necessary to argue issues and present them to a judge. Frankly, these apply to judges as well, because as they confront matters and look at tense issues, how they comport themselves has an outcome, because they are an important example, indeed a mentor, if you will, to the legal profession by how they demonstrate their understanding of principles and how they apply them to their job as a spokesperson, if you will, or an example, if you will, for the judiciary. And to have respect and understanding with the people who appear before you, this is a good thing. these principles of civility that are applied in a structured way to the judiciary enhances their credibility as they speak to attorneys and make difficult decisions. So it doesn't matter where we travel in the world of the attorneys and their roles, whether, again, beginners making their way, veterans, judges, doesn't matter. This applies to everyone with potential significance for what occurs as a result of your behavior. Next slide, please. Tom?
William Shakespeare summed it up this way: and do as adversaries do in the law. Strive mightily, but eat and drink as friends. That's a great statement, a great saying. When we think about how to be civil and the benefits that come from it, it's really amazing if you stop for a few minutes and think about it. Civility, maybe first and foremost, promotes good relationships. The practice of law, by and large, is all about relationships. We can have differences of opinion, and we will. We can be on opposite sides of a case, and we will. We can have witnesses and parties who disagree, and that'll happen. But in the end, we want to remain civil. We want to promote good relationships. We want to make sure that the best version of ourselves is seen by others as often as possible. Another benefit is it helps with networking. I think we can all agree that those of us who have seen people act with civility, with integrity, with respect toward others, often have a tremendous network of friends, clients, colleagues, and they benefit from that tremendously. There's also incidental decision makers. What do I mean by that? If you're engaged in civil conduct and you're in court or in a deposition, others who witness that, they remember that, they understand that. The example that Tim gave today at the start about his first time in court, he remembers that years later. Being civil, being courteous has tremendous benefits for all of us. It also only enhances your reputation. At the end of your career, when we're all engaged in the rocking chair test, when we're on our front porch, rocking in our chair, and we think back over our career, we want to be able to say, we engaged in civility. Our integrity meant something. We treated people with kindness, with respect. We went out of our way to try to understand perhaps a point of view that our client or ourselves didn't necessarily agree with. We were self-aware. We put structure into place so that we conducted ourselves the best way possible. And then there's also the economic benefits of following the golden rule. The economic benefits include not paying sanctions, not engaging in silly motion practice, not wasting time on things that really don't merit time. Because after all, if you're responding to a nasty gram or you're responding to a motion for sanctions, those kinds of things eat up time, energy, and in the end, they're demeaning. They're demeaning to each of us individually and as a whole to our profession. So at the end of your career, you want to be able to say, I employed and always used the golden rule. And in the end, that's really what Bob and I want to say. We want you to make sure to remember and use the golden rule, structure yourself so that you know how to respond to people who may engage in improper or uncivil conduct, and be prepared to face that as you meet the challenges that our profession presents. Bob?
So as we move towards the end of our program, I was struck by Tim Diemer's example of what occurred as a young lawyer. And as I contemplated his remarks, it struck a chord with something that I actually did to structure my behavior and the applications that occurred. In my very first trial, really within less than a year of being bar admitted, I thought I did a heck of a job trying the case. I was in Wayne County Circuit Court. We concluded with the jury not yet deciding the outcome on a Thursday night, which meant we come back on motion day for our verdict. And around 10:30 or so, the jury had a verdict, and the judge, in front of everyone, brought in the jury. And guess what? I lost. Now, this is my first civil trial, and I'm devastated. First, I'd been confident that I'd done well, but the devastation was quite overwhelming. And as I'm packing my bags, remember, I'm in a packed courtroom. There must be 50 lawyers there. And one individual walked out into the hall and gave me a guy's hug, put his arm around my shoulder and said, basically, don't worry about it. Well, that took a while to soak in because I was still despondent, limped back to my office, blah, blah, blah. But what I did is I made a decision that the relationship with opposing counsel was important. And I was so self-absorbed, I really didn't go congratulate the other side for winning. So I took care of that. I made some phone calls and appropriately congratulated, wished I hadn't marched out of the courtroom all sad and depressed. But that in turn led to another structural change that had a huge application, which was the friendships I developed. And I committed to have a drink, go out for a cocktail after every trial. So verdict rendered, I made a deal with the other side that that's what we would go do. And over, I don't know how many trials and how many verdicts, one of the most satisfying things was getting to comfort the opposing attorney if they lost, or simultaneously to congratulate them if they won. And the collection of friends that I assembled is remarkable. As Tom says, look back at your career and what will you remember? And I don't know that I'm going to remember that I was particularly civil, but what I will remember is the relationships that I established in a wonderful profession. So as you contemplate this, it isn't just about financial success. It isn't just about reputation or ego as a skilled lawyer. What the heck, it's as simple as having great relationships with people in a great profession. So when we argue or advocate or submit to you today to follow the golden rule, please recognize the myriad of applications that rule has, the outcomes that can be achieved, and results that are both substantive for you and your clients, and finally, personally rewarding. Tom?
Thanks, Bob. Tim, I think that does it for us. Questions? Chad?
So we do have some questions from the audience. First of all, Tom and Bob, once again, thank you. This has been a wonderful presentation and certainly very timely. While certainly civility issues and the decline of civility and professionalism is not new, it's been a constant and perhaps deteriorating course. There's no question that the pandemic and isolation and not being together in person has aggravated the situation. So this has been a wonderful program, and even from our audience and from other audiences that have seen this or similar presentations from you, from Bob, from Deb Freed, all have had glowing remarks. Sylvia Mansour had a question that I think is both very insightful and also a little, it bothers me. What she writes is that she's being ignored by opposing counsel. They're not being necessarily what she calls uncivil. Instead, they're just ignoring her, punting her to legal assistance, ignoring her calls, not responding. And pre-COVID, they would have run into each other in court and that she could have taken care of it. She feels like she's being ignored and having to chase people down, and it's very frustrating to her. And of course, one of the things that comes to mind is, it really bothers me to hear, Sylvia, and I'm sorry that you're experiencing that. And I can't help but think that that same sort of behavior, I don't know that if you were a male attorney, if you would be treated with that same kind of disregard. And it really bothers me to hear that. Does the panel have some advice for Sylvia about how she should handle that? And also, Sylvia, any other questions you have, please let us know.
I'm not sure where to begin, Chad. The premise that one would be ignored, not responded to, that they would somehow be treated as irrelevant is disheartening. And to think as well that it might be motivated by gender, race, age, whatever, makes it even more disheartening. Now, response is difficult, but I think the best I can come up with to a question like that is one must be true to the structure that they have established. So as one thinks through what to do in a situation like this, what would you want to do if the roles were reversed? And I think the answer is you continue business as usual. You do that which is necessary to communicate, whether it's verbally, you place the same phone calls, you participate as if they're going to respond. You ignore the slights or the disrespect and persist, but persist in a manner consistent with the kind of civility that you would want evidenced to you under the circumstances. That's going to serve two purposes. The first and the most important is you're true to yourself, the values that you have developed through principles that you have structured into your practice. But the second is because of the nature of our work and the professional requirements that are associated with representing our client, those who ignore, defer, deflect, fail to respect, who do not participate at appropriate levels are themselves, I believe, subject to the professionalism standards that we talked about at the outset. These are inconsistent with those standards. They have application to specific issues and are potentially sanctionable. So the consequences of this, and I hope they become real over the years as we evolve and make civility a major priority. These things have professional consequences because they fail to advance the needs of the parties to fully address and resolve the matters before them or to seek judicial redress if that is what is absolutely required. So in that context, I think these are responses, but I will confess I don't find them fully and completely appropriate for that which has been outlined.
But Sylvia, I do want to very much thank you for bringing this to light. And it reminds me, earlier this year, Judge Amy Renee Krause, who's actually one of the on the audience today, came to a law school class I was teaching of all female students. And she had some wonderful advice for those students that I'm going to impose upon her to, at some point, return to our section. She's been a repeat speaker for the section, along with some of the very wonderful, powerful women attorneys that we have on our council section. Deb Freed, Donna McKenzie, Stephanie Arndt, Jenna Wright-Grieman. women who have built legal careers that are astonishing. And you've given us an inspiration to have a presentation focused on these very issues, especially for young female lawyers and dealing with this kind of behavior. And it is uncivil, it's unacceptable. And I'm sorry that you were subjected to that. Certainly whoever is doing that should be addressed. Tim, do you have another question from the audience? You know, Don Jones actually writes something that's important as well. Don, thank you for being here with us. He writes, it's important to speak highly of those who are excellent examples of civility and integrity. Take a moment to get to know opposing counsel on at least some personal level. That's so true. Certainly those who are role models and mentors and leaders in the area of civility and professionalism should be recognized. It should be the norm. It should not the exception, but those who are go above and beyond should certainly be recognized.
And Chad, if I can chime in, I was going to follow up that comment, which I thought was well taken, that it's important to promote civility and honor those who do represent civility and professionalism, the best of the bar. And on that note, I'd like to highlight the Respected Advocate Award that's presented each year by the Michigan Association for Justice and Michigan Defense Trial Council. Each year, MDTC honors a plaintiff's lawyer who is not only a highly effective advocate, but does so with class and professionalism. And in turn, MAJ honors a defense lawyer who also exemplifies the best of the profession. And that's one way where I think we can honor civility and honor professionalism is through that award. And that's something I know that MDTC and MAJ are both very proud to do each and every year.
Absolutely. Well, and we look forward to hosting them at future state bar meetings, hopefully again. So that'll be great. We actually have a comment that someone texted in. Understanding that people have different sensitivities, can the hosts comment on the difference between someone simply being a jerk versus incivility? I don't know that there is a difference, unless one of them's your husband. You guess who that text was from.
Chad, I'll try that. I don't know that there is a significant difference, but I know that in those situations where I have experienced hostility or incivility, I think the best advice I can give is to respond, but only after thinking about it. Give yourselves 24 hours. I always thought that was a good rule. I still use that rule, and it may be important in situations where you've received hostility to recognize that the person who is on the other side may be having a bad day as well. They may be experiencing significant loss in their life or problems in their life. I know this has happened in my own profession or practice where I saw somebody engage in what I thought was unusually uncivil conduct, only to find out that there was other issues in their world that was impacting them. So in those situations, sometimes I'll text back, got your love note, send me or call me when you got a minute. And if I don't get a call back, I'll call them. And oftentimes what I've said is, I couldn't help but feel that your comment was a little over the top or a little aggressive. What's going on? And that goes back to that relationship part. It's important really to try to foster relationships, good relationships with people, show interest in people that you especially work with on a regular basis. And I would just encourage you, humor sometimes is the best way to handle and to respond to uncivil conduct.
You know, speaking of the 24-hour rule, certainly the 24-hour rule before sending an email and having some chance for reflection is good. Mr. Cycli actually responds about a 24-hour rule as well. If a lawyer is not responding follow up after 24 hours. May have the courtesy of a response to my last email and attach it. And if they continue to ignore you, that those can be attached as exhibits. And Judge Amy Renee Krause of the Court of Appeals also identifies that if counsel is not responding to you, please do make a record in the trial court when you're unable. It will be important to know on appeal. Randy Yipe, who was court ordered to be here for some extra civility lessons, writes that over and above recognition, it's important to encourage civility within our own firms. When you hear anecdotes about one of your own infirm colleagues who has been uncivil, it's important to address them intentionally and internally. Randy can address them internally. Thank you, Randy, for that. By the way, for those of you that don't know, Randy is certainly a paragon of civility, and he's been on the other side of many cases from my partners and I in our practice, and exemplifies the kind of civility and professionalism that Bob and Tom and Tim have talked about today.
And there's one more comment that came at the bottom there, Chad, which I thought was an interesting question. It can be a frustrating experience. And it's from Janet Hamilton. Any suggestions for dealing with judges who routinely allow attorneys to behave reprehensibly in their courtrooms without any admonishment or repercussions?
I have an obnoxious example where it actually worked, but it was a risky decision on my part. I tried 3 cases in a row, literally back to back to back, all civil cases in front of the same judge. We were certainly tired of each other by that experience. And in the 3rd trial, when frankly I hadn't done anything else but be ready for one after another, try the cases, etc., he looked at my exhibit binder and told me that it was useless, it was incomplete, and he threw it at me. So I paused and I didn't know what to say. And I said, Your Honor, if you wish to throw things at me, I would appreciate it if you would come down off the bench and just simply sit with opposing counsel. Now, I didn't really have a lot of time to process that. But what he did is he took a break and he came back out and he apologized. Now, I don't know how to deal with this issue. And I've been confronted with this a couple of times, and I've watched it in courtrooms a couple of times. And there's no good answer because of the power and authority that rests with the judge. And the ability to get a private moment and say, hey, I'm sorry I ticked you off. I didn't mean to take you that direction. If there's anything I can do to make this better, I'd like to, particularly if you're in the middle of a proceeding, is not a very convenient time, particularly with opposing counsel potentially there. So trying to invoke a little humor was what I did. Maybe I would be considered not very funny, but I tried to make light of the circumstances, and it seemed to work out in the subsequent years of being in and out of that building and having motions or trials again in front of this individual. It worked. But I think the question you pose is a very serious one. And our community of lawyers includes judges. Judges are responsible for civility as well. And in fact, the example they set is in many respects more important than the example we set. So it's a great question. There's no great answer. Diminishing tension is immediately required. And how one does that and then seeks an opportunity to break bread, so to speak, have a conversation. Ex parte conversations are a problem. So that element enters the picture as well. But figuring out how best to deal with this is a very significant problem, particularly in the remote world, where some judges have evidenced less control of their emotions or their tempers in those settings.
Hey, Bob, one of the judges in the audience asked that the lawyers attending please send examples of uncivilized or unprofessional behavior by judges that wasn't something that would be perhaps grievable, but something that would made them uncomfortable, felt like they or their client wasn't getting a fair hearing, or was just something that should be addressed. If and Tim put in the chat, if you could please email those examples to Tim Diemer, and we'll put his email up, or he can say it out loud. We'll assemble those. We'll anonymize them, so we'll take away your name, the judge's name, and just put the fact situation in. And then we'll send those to the judge that's requesting them. And we'll also send them to Judge Christopher Yates, who is a frequent speaker for our section, and also was just appointed to the Michigan Court of Appeals. Judge Yates is, again, one of those judges that exemplifies the kind of demeanor, civility, and judicial temperament that we're all looking for. And certainly as president of the Judges Association, he can also be influential in sharing these concerns with judges across the state. And if that's something that the section needs to coordinate with, certainly we're in a position to do that, and happy to. Let's see, Tim's email is tad@jacobsdiemer.com, and that's in the chat box for anyone that wants to see it. Samantha Orvis from Guerin Lukow, a well-known firm and home to the section's leadership member, John Whitman, writes that there was a senior male attorney who wouldn't speak to her, never spoke to her until in 3 years of litigation, until he needed a trial adjournment. He would only speak to Samantha through his assistant, and only when he wanted or needed something. Never responded to her communications or requests. So certainly, and there is another response from Lynn Corrigan that says, female lawyer issues are real. Again, thank you for identifying and flagging these and highlighting this. And it is something that the section will be actively addressing in the future. So again, thank you for bringing these to our attention.
Actually, Chad, I'd like to supplement that. Both the negligence section and ABOTA have strong commitments to diversity. In the negligence section, we've taken every example of potential members to council and have always looked for women and minorities to be part of us. It's consistent with our bylaws. It governs the leadership, and there's been a overriding commitment. And we think it's a really important issue that the council be reflective of our legal community. A little more difficult in ABOTA because we've noticed that women do not receive the opportunity to be trial counsel in a wide variety of settings, and that deference is not given to their skill development or their skills as a lawyer. Experience is denied to them, and it's an issue that we're trying to tackle and address so that those who make decisions as to who should try their cases should give recognition to women. So this is not a casual issue. It is not an insignificant issue. And it's one that tests all of us in the profession as to how we go forward with a legal community that is truly reflective of the lawyers who make it up.
Absolutely. Thank you, Bob. And again, we certainly truly all appreciate the ability and the collaboration with the American Board of Trial Advocates and the section. Having Tom and Bob as both past chairs of ABOTA, and Bob is the current chair of the section, Tom is the immediate past chair, has been a wonderful means to collaborate between two important organizations in our profession, both committed to advancing professionalism and civility. I think that is all the questions that we have, except there is one: how do we get the handouts? This is from Thomas Anderson. Tom, if you go to the chat box, and just scroll up to the top, Matt Hinkle, who was kind enough to put those right in the chat box. And also there'll be an email that goes out that identifies the downloads from the Eastern District, the Western District, and the Supreme Court. And he just put them up again. So now they're at the very bottom. There's a shared resources upload link. You'll have them all. And we can also send that out as an email if anyone can't get them from the chat box. We didn't get a chance to say it at the outset of this presentation, but for those members who don't know, our executive director, Madeline Lowry, and her staff at Shared Resources are essential to bringing you the programming that and continuing legal education that the section is able to provide, and also just the day-to-day operations of the section. Every day we have events that occur for the section, meetings, webinars, meetings among the officers, phone calls, and Madeline Lowry and her team really help to coordinate that. So thank you to them as well. And Matt Hinkle, he's the IT guru over there. I can't tell you how many fires he has put out and how many things, computers he's had to put together online to help us all handle things effectively. You will get a survey about the presentation. I encourage you to please return the survey, complete it. Let us know your honest and candid comments. What did we do good? What can we do better? And also, very importantly, what type of programming and CLE are you looking for from the section? I do want to give Tom and Bob one more credit before we wrap up today, and that is this program was made available at no cost to members, to judges, to judicial staff. And that is part of the commitment to service and member benefit that Tom and Bob have brought to the section, to being able to offer free programming rather than paid CLE, and to promote civility and professionalism. And so we thank them for that and for their leadership on the section as well. So certainly a big round of applause for Tom and Bob and Tim. Thank you. Janet Hamilton said this seminar needs to be regularly repeated. Couldn't agree more. Hopefully, and Tom and Bob are working to make this a regular event. So thank you all. And with that, if no one has any more questions or comments, we will end the program at this time.
Thanks, Chad. Appreciate it.
Chad,
Thanks, Tim.
everybody, thank you. Much appreciated.
Thanks, Bob. Thanks, Tom. Thanks, Chad. Thanks, everybody.